All right, picking back up again with Chapter 4 in the Law of Journalism and Mass Communication. We're dealing with libel and emotional distress in the plaintiff's case. We're going to get into some of the elements. And again, with the last video, we talked about the elements, page 150. You can get that. Here's sort of a quick summary. You got a statement of fact that is published concerning that plaintiff that is defamatory. And there's causation where they cause damage or harm, and the defendant can be held at fault. All right, publication. This whole concept of putting together the information and then putting it out there. If you've created that content, if you own the content, then you can be held liable for libel. So there's that old statement that if a tree falls in the woods and there's no one around, does it actually make a sound? The same thing with publication. In order for a statement to be libelous, they have to show that it was made public. So a third party has to be involved. Someone other than that plaintiff and defendant has to have some connection to it. So it has to have been seen or heard or understood, and so they have to receive that information. So normally what courts can do is they will make an assumption. It's called judicial notice. And if the materials have been put out to the public, then the assumption is that it was actually heard. So publication is putting the information out there for other people to take it in. So that works if you are the content creator, or if the person is republishing that information. Oftentimes what the media does is they will publish somebody else's information. So they'll publish somebody else's statements. Maybe it's possible where you're getting something from the Associated Press, you're taking a news story and you're putting it back out there. The thing is that someone who republishes is just as responsible for the original content creator for distributing that material as the originator of that material. There are distinctions between republishers and people who have control over the content, and then people who are just considered the conduit. So you can have certain people that are held exempt, and there is the Communications Decency Act, which has certain defenses in it. We're going to cover that in the next chapter, so we'll go into those defenses as far as the details on publication. But so in dealing with republication and that republication exception, just at a very basic level, when you're talking about vendors and distributors, people who are selling or distributing that information, but they didn't create the content, that is not the same as being the publisher. So they don't control the content, and they did not read or edit that information. So companies like bookstores and libraries and newsstands, they're not expected to know what the content of everything in those publications, what that content is. Now, this also applies to Internet Service Providers, or ISPs, treating them as distributors, not as publishers, so they're not liable for libel either. And again, the CDA is something we will talk about in the next chapter. And there is a case, it's Zeron versus America Online, where there was false information about the Oklahoma City bombing, and the plaintiff sued America Online for defamation of character, and the case was dismissed because AOL was not considered a publisher, merely the conduit. So the publication or republication exception, and that's where certain parties that seem like they're involved are not going to be held liable, because again, it's control over the content. All right. Then there's this whole concept of anonymous publishing. Now, it's part of our First Amendment rights that you have the right to speak, and you don't have to have your identity tied to that. So, you'd have a quote from Antonin Scalia, who had just recently passed on this. He was on the Supreme Court as one of the justices. Anonymity is a shield from the tyranny of the majority. So protection against the ridicule and the shaming and possible repercussions from speaking freely. Again, one of the ways that the Constitution protects people with their free speech is that they don't have to state who they are. Now, that has to be balanced out because it can't be where people with impunity will just be making statements and causing harm and never be held accountable. So that has to be balanced out. The First Amendment right to be anonymous versus that accountability is where the courts come in. So we talked about, when we were dealing with the Schutz and lawyers and talking about process in the courts, the different ways to obtain information. So it is possible to discover an anonymous publisher and unmask them so that it would be possible to sue them. You can't sue somebody if you don't know their identity. So through the discovery process, it is possible to request information and then find out the identity and add that person into a lawsuit. Depending on the jurisdiction where the lawsuit is brought, different laws are going to apply as to the burden on the plaintiff being able to state the need to overcome that First Amendment right and to get that information. So in the textbook they talk about different states, like with Virginia, it's a lower standard. You just need to show that the identity of the person is central to the case. Whereas in New Jersey, you have to be able to present enough of the case to withstand a motion to dismiss. So more than just a plain statement of the facts you'd get in a complaint, you'd have to have some additional information. And then a state like Delaware has a much higher standard, and you have to be able to prove, if you're the plaintiff, that you withstand. You have to have enough information to withstand a motion for summary judgment. So you have to have more facts in place in order to move forward and request that the identity of that anonymous publisher, that they would be exposed. Okay, so that gets us through our first element of libel, which is publication.